Сайн байцгаана уу хүнд үзэгчдээ. Өнөөдөр манай дефакто нэвтрүүлгийн зочноор Монгол улсын шүүгчдийн холбооны урилгаар Монголд ирж ажиллаж байгаа Америк нэгдсэн улсын даван заалдах шатны шүүгч Жэймс Wynn гэж хүн оролцож байна.
Жэймс Винн Америк нэгдсэн улсын холбооны шүүгч. Хойд Каролинагийн их сургуулийг сэтгүүл зүйн мэргэжлэр, Виржиниагийн хуулийн сургуулийг магистр, Маркютийн хуулийн сургуулийг доктор зэрэгтээ тус төгссөн байна. Америк нэгдсэн улсын тэнгисийн зэрэгт нөөц офицероор 30 гаруй жил цэргийн шүүгчээр ажиллаж байсан ба 2009 онд тэнгисийн цэргийн ахмад цолтой армиас чөлөөлөгдсөн. Америк нэгдсэн улсын 4-р тойргийн давж заалдах шатны шүүгч бөгөөд 2009 онд ерөнхийлөгч Обама томилж 2010 онд Сенатаас бадалгаажуулсан.
Good evening.
Good evening.
Welcome to our show.
Thank you for having me here.
Please tell us about your mission here, what you have been doing here in Mongolia.
This has been a wonderful opportunity. Of course, I serve as a judge in the United States on the United States Court of Appeals for the Fourth Circuit. I've been a judge for 32 years. The United States State Department, through its embassy here, connected with the Mongolian Judges Association and determined that perhaps we could share some ideas in terms of how our various court systems work, and perhaps the United States could learn some very good things from Mongolia, and perhaps I could share some things that we could donate in terms of ideas here.
So how was it?
It has been phenomenal. Amazing, I would say. And I say that because the level of participation, the seriousness and the interest of the judges and the stakeholders has really been uplifting to see that there are so many who rightly care about having fair and impartial courts.
It's also because in our society we assume that the role of judicial system is so important. That's what we have learned for the last 30 years of the road of democracy. And yet there are a lot of things to improve in judicial system. Probably that's why it is the big interest also not only the judge themselves but also public. And let's talk about first a bit about the judicial system of the U.S., the structure and how this appeal part comes into.
Fundamentally, one of the big things you need to know about the U.S. system is a common law system, one that was established over 200 years ago. In the United States, like here, there are three branches of government: the executive, the legislative. In the United States is the United States Congress with the House of Representatives and the Senate. And then there's the judiciary. But in the United States, 200 years ago, they began something that was fairly unique. They made the judiciary a co-equal branch of government. So in essence, if I were to give you an analogy, it would be like a three-legged stool. Each branch has checks and balances that offers accountabilities and provides the governmental service it should, but to weaken any one of those branches would severely put that stool in imbalance.
Check and balance system of these three legs of the
absolutely
table. That's what we're trying to learn and trying to keep. But however, the check and balance are always not there, at least to the level of satisfaction of the public. What does then appeal system goes into?
Well, of course, in the United States, the Constitution requires due process of the law. And that essentially means that every citizen is entitled to have a fair day in court and to be heard, to be given notice. And after the trial process has completed, our system provides for an appellate process. That is, it can be appealed. Typically, they are not issues of fact on appeal. They're issues of law. Were there areas or procedural areas below? And if not, the matter is simply affirmed. If there are, we may send it back for a retrial or we may reverse it. Matters come from the district court in the United States to my court. And then from my court, if there is an appeal, it will go to the United States Supreme Court, which is the final arbiter in our country, not only of statutory law but of constitutional law.
So there are at least three levels: district court, state court, and then the federal court.
Well, let's be clear. There are two systems in the United States. There are 50 different states that forms the first system.
Yes.
Each of those 50 states are sovereigns, and there is a whole court system within each one of those 50 states that includes trial courts, an appellate court, and a Supreme Court. Those courts adjudicate matters under the state constitution and matters that arise under state law. Under the federal systems, all rights that are not expressly delegated to the federal government remain with the states. Thus, there are a number of federal laws, some which arise because of an act called the interstate commerce, meaning if there's something that affects matters between states, it's a matter of federal law. And then there are purely federal agency type laws. And then there's the federal constitution. All of those laws are adjudicated by the federal courts. And the federal courts are established by nomination of the president with consent of the Senate. And then once a judge is confirmed, a judge on the federal level sits for life.
For life. Now, how many people are there at the federal Supreme Court, federal court?
Well, the federal district courts, there are around 600 or so of those judges scattered across the country. In the federal circuit court, at about 163 odd judges, and then there are 9 justices on the Supreme Court.
You said circuits, and you are
I'm a circuit court judge.
One.
Yes.
What is the circuit about?
There are within the United States 13 circuits, 2 of which is a federal circuit, which handles complicated federal type cases. Another is a D.C. circuit, and then there are 11 various circuits across the country. Each one of the circuits have states within their jurisdiction. You may know that case law in the United States is precedential. That means that it is stare decisis. It means once a case is written, it becomes the law of that particular circuit. So any case I write becomes a law of the Fourth Circuit. We are not bound by the laws of other circuits, but we can choose to be persuaded by them.
So the Fourth Circuit, which states are covered?
We're covered with Maryland, Virginia, North Carolina, West Virginia, and South Carolina.
More or less territorial part.
That's exactly right.
So part of this common laws you were referring to, Britain and UK, USA, a few countries. Many countries has a kind of the civic law system. Mongolia is kind of combination of both. Do you agree with that?
I absolutely agree with that. I also will say to you that many of those who started out as civil law, I heard from some German professors this week, and I can tell you some aspects of the common law has actually been imported into the civil law system too.
So common laws, just with very simple understanding, is if something happened and about that case you raise and whatever you have decided, the judge had decided on that file or case, then it is becoming like, in the similar cases, it will be prevailing decisions, right?
That is correct.
So in that sense, in Mongolia, for example, because it is not combination of, because it's a combination, sometimes they use the civic system or law, which is written in general. So which one do you think is more close to the truth, or close to more effective in really establishing such a system that people think it's fair?
Let's be clear. There is no perfect system that has ever been created by any country at any time. There are some that work perhaps better within their cultural setting. From my perspective, the common law system in United States has evolved over 200 years. It surely does not look like it did when it first started. One of the, I think, the amazing and I think beautiful things that's happening here in Mongolia, you've only been doing this for 30 years. And to see the progress and to see the interest and the conversation going on is enormously encouraging. So when you think of the combination of them, I think all systems are a combination to some extent. You should be. Because if you are operating as a system and you determine there is something you can do better, then you should consider it. Can I give you an example? I'll give you an example. It has not been enacted, but some years ago, you may not know this, but in addition to being a judge, I spent a number of years, over 30 years, in the United States Navy as a reserve officer. I was a military judge. Mm-hmm. And so I would travel to different places. You were a captain in the ring. I was a captain at the time. That's right. I retired as that. And I went to Japan at a naval base, and as a military judge. But the Japanese court officials there in the legal system asked me to come and lecture on the American jury system, I was amazed. They were even interested. And you can see there are aspects of a jury system that may not exist in a civil society or in fact, it doesn't exist in many parts of the world, but there are beautiful aspects of it because it imports citizen participation, and you can only imagine that at some point in time it has to enhance the public's confidence to know and participate in the process itself.
You touch upon the issue of judicial system and public. Is it something together? And I understand the many subjects of your lecture in Mongolia has to do with the public relations of the judicial system and how united, how one monolith system is this. Please tell us about that.
You know why that's so? When you think of the three branches of government, Alexander Hamilton, who's one of our founding fathers in the United States, he called the judicial branch the least dangerous of the three. Uh-huh. Well, the reason being the judicial branch has no armies. It does not have law enforcement. Uh-huh. In other words, it relies primarily on the public's confidence and trust in the integrity of the judicial process, because every country must have some means of adjudicating disputes between its citizens, between businesses, and between entities. If you don't, then you may cease to be a civil society. So I think the courts in and of itself are respected. I'll give you another thought. I spoke with some of the members of the banking and commercial community here yesterday, and I said to them, you have more of an interest in fair and impartial courts than perhaps anybody. And you know why? Who wants to do business in a country or with anyone if you believe that the courts will not protect your contracts, will not protect the type of business interests and things that you engage in, that you work hard, and then you find out that the courts are corrupt or they're subject to bribery? Who would do that?
That's the problem here. And we have cases where judges are involved in unfair system of the judicial system. And you said just now that, or you said Hamilton said that, the least dangerous branch. And why? Because it has no law enforcement inside.
That's true.
What do you mean? Law enforcement is not a part of the judicial system?
It is not. It is part of the executive branch of government. It comes under the judiciary relies upon its judgments and laws being enforced by the executive branch of government.
The government.
No question.
So, okay. Now, a very interesting question. Another one. Maybe you have noticed. Mongolian, maybe some countries also, they call the Minister of, in our understanding, justice. In Mongolia, it's called Ministry of Internal Affairs. Law and Internal Affairs. Yet their English website name is Ministry of Justice. So that you see this difference, domestic affairs and justice. And how do you call it? Your system is justice, Ministry of.
I don't really know the kind of entity you're talking about, but it really goes more to what is the function of this entity rather than what you call it. There are many departments that are called certain things, but you really want to know what the function. My point in terms of the function of the judiciary is we have a very set, and by the way, in the United States, it is a co-equal branch. It means the judicial branch disciplines itself. There are checks and balances, as I indicated, and there are interrelated things that happen within the courts. For instance, the Constitution of the United States is adjudicated exclusively by the judicial branch. So if the legislature passes a law, then the Supreme Court of the United States can invalidate it. My court can invalidate it if they pass a law that is unconstitutional. In turn, if the legislature passes a law and then the president decides that that law is not something that should pass, he can veto it. But get this, that same Congress can, by a 2/3 vote, override the president's veto. And then ultimately, in terms of where is the accountability with the judiciary, well, the president actually nominates the members of the federal judiciary with the consent of the Senate. So the Senate then has to approve it. And then it goes through a complete vetting process. Plus, at the end of the day, if there is a judge that needs to be removed, there is a process by which Congress can actually impeach and remove a judge from federal court. So there are a lot of back and forths there that keeps things in balance. They're called the checks and balances, as I mentioned, that helps to keep this whole system. But, you know, I'll go back to your initial statement. It really depends on the public's confidence. Think about it. When a law is passed by parliament or legislature, it is passed based upon the people's will. It doesn't have to be just. It is the majority's determination, hopefully with consideration of the rights for the minorities, that results in a law. A court case, which is common law, is to be determined by a fair and impartial judge upon the facts, basically upon justice. So you can see the two types of determinations of how law is determined can be vastly different in a civil society where you have total adherence to the code or to statutes that are passed on public will, as opposed to a common law system where you have cases that we would hope are being passed, are being adjudicated and decided based upon justice, principles of justice under the laws that have been enacted. And you know, for that reason, common law has a different kind of approach.
Yet there is differences between judges, whoever is nominated by whatever president is. For example, you are nominated by President Obama.
Yes.
Now recently with the passing away that lady judge in the U.S., nomination comes from President Trump's side, right? So how does it reflecting the public opinion on that issue? So when you nominate judge from one president, from another president, different, so it's sole right of the president to nominate completely whatever he wants.
That's true, except the United States Senate has to approve it.
And if there was a case when they have not approved?
There have been many cases where they've not approved it. There have been many cases where an individual has not even been nominated because he doesn't just nominate someone, he nominates it based upon a very, very intricate vetting process, looks into the background and examines the morals and the work they've done.
So even when the name comes out to the public and to the nomination, it takes how long it takes time?
It takes a long time. In some instances, it can go within maybe 2 or 3 months. In other instances, it's gone 2 or 3 years.
So the public has also an opinion if there is anything?
The public has constant input and opinion on these nominees. There's no question about that.
Okay, let's talk about the civil society in the court system, judgment. What is the relations that makes the system more fair? What is to be done from the civil society side, media side? You have been also working in media. So what is the relations between these three?
You mean in terms of the three branches of government, or between a civil and a common law?
Society, media, and judge system, judicial
yes.
system.
Well, I'm glad you brought up the media, because in the United States, that is such an intricate part of our government. So much so, some people have actually called the media the fourth branch of government. And I'll tell you, as you will understand, those who serve in the media, they also have a standard of conduct. They have a means by which they report the news. They are the eyes of the nation, and they look upon. When you asked me earlier, how did I think of Mongolia, in every instance that I spoke to of how I thought of Mongolia, I had received it from news media. I'd received it from those who reported back. The interrelationship is important in government because in the judiciary, it depends on the public's confidence. And many times there's no media presence for a court. It does not go on TV by itself. It does not write newspapers. It must depend on accurate reporting and balanced reporting. And what does that mean? Of course, much of it comes about that there's a First Amendment in the United States, as it is here, which is a freedom of speech. That is so important in our society. And we really, really work hard to protect it. Does that mean that I, as a judge, and other judges will be criticized? Absolutely. You can see criticisms from judges in the United States every day of the week. But the First Amendment has restrictions. That speech does not permit you to engage in speech in an attempt to influence the court. It does not permit you to engage in speech that will threaten the court or that will unduly and illegally damage the reputation of the courts or of judges. Because I think fundamentally to do so would indicate you are not only someone who's doing that conduct, you in fact are going against the very foundations of our Constitution and the very Constitution of the United States.
Yet it's so difficult to make a difference between whether the person or the subject is trying to influence or not, because you go into the details of each case by delivering those speeches.
That's exactly correct.
How you would work on that?
Well, isn't that what this is all about? Adjudicating difficult situations. There's nothing easy. There are no easy cases that come to my court, and what you just described is not an easy solution. Yes, it is a problem to determine when one does this or one does not. But in those instances where it's obvious, we definitely adjudicate and deal with those. In those where it's not, that's where the media comes in to offer balanced reporting and the other side of the opinion to give you a different perspective of it.
Yet some courts are open for public, for media, some closed. Who makes the difference?
Well, all courts in the United States are open to the public. Mm-hmm. Now, to the extent that media is allowed to come in and broadcast the proceeding live, very few, if any, courts will do that. And the reason is they do not want to turn that court setting into a public circus. But they do allow the media the opportunity to cover it. In other words, audio, for instance, in my court, all of the arguments and all of the matters are available online, contemporaneous with them being done, in which you can hear the actual arguments.
Audio, not video.
That's right, audio. You can. That's exactly correct.
Okay. Interesting position you're saying. All courts are open for public, you're saying, and yet not open to media.
They're all open to media.
All media. Then,
but is there a right to take a picture? Is there a right? What does the picture show when you're talking justice? If you look at the statute of the lady holding the scale of justice, there's a blindfold on that lady, and there's a reason. Because you do not want cameras to be focusing on perhaps the demographical characteristics of individuals or the inflections of their face to try to import justice. Justice is blind.
I understand, but the picture is, what you are describing is very interesting. That person can be audio recording, but not video recording. That's what you're saying.
I'm saying that the proceedings themselves are available and made by the court itself. Available
afterwards or on the line?
Contemporaneous with it being done. Uh-huh. So if we have an argument session next week, which we will, by the way, every one of them you can hear in Mongolia at the same time it's going on there.
Huh.
Yes.
And not yet, no video.
Why would you want video?
Well, the concern is that's the conversation I would like to more go into deeper, because audio also can transmit the emotions, feelings of that person.
Okay.
Video even better. Mm-hmm. So, what a difference in that case. I mean,
well, you have to understand the court is deciding the matter, not the public. we are not transforming courts into open public type trials. When we hear cases, most of the time an individual is only going to hear a part of it. Cases are decided on all of the evidence. If you want to go in and video from day one when the proceedings start and read every brief, listen to every witness, cover every single thing there, perhaps yes. But that's not what happens. Television and media operates and can only operate in sound bites. And who determines which bites are given? They do. And so it is important to capture the role of a judge has to listen to every bit of it. That's what you want them to do. Hear all of the evidence, not that part that was exciting or it flamed up at the last minute.
It can
and
be partial.
Well, I think all things can be partial. I don't want to say it is partial, and I don't say it would be. I'm simply saying the roles are different. The roles of media. I don't see how media is
so in that sense, exactly in that sense, how do you see the reaction from Mongolian media side during your? There should be something similar to what I'm saying, but I'm just wondering.
I can tell you there's no shortage of media interest in the cases we cover. If you take, for instance, the most recent case that the United States had in which it overturned the Roe versus Wade decision on abortion that had been in existence for 30 years, it was covered by the media like no tomorrow, and it remains to be covered. I have not heard anyone yet complain they cannot get enough information on it. In fact, they get more information than they possibly want on it. And it comes because the American society is very litigious and is also very much in terms of commenting on things. So the opportunity to examine the law, because our opinions are published, they're out for you to see. The reasoning is there. The proceedings, there are people in the courtroom now. It doesn't mean you can't sit in the courtroom. There are always people in the courtroom, and they give their observations. You have the live coverage of it in terms of what's going on. But you know what's important? It's not really what's going on in the court. It's end of the day, it is the decision that the court renders. That's the important aspect.
So then when the courts are open, you said, it's by constitution they are to be open? Or
yes.
By constitution.
Open and
so
access.
say a small room, but the case is so much public wants to see what happens then.
Well, you can only get so many in a courtroom. You know that if you have a high-profile case, you might could put 100,000 in there that want to hear that case, but who has a courtroom for 100,000? So what you
first in, first served?
Well, each court determines that. If you're talking about the United States Supreme Court, very difficult, but they have a process that allow for individuals to sit in there. And then they may have some opportunity for you to hear otherwise. As I said, all of that's recorded, and you may be able to pick up that.
So all courts, you said it's open in the United States. Here, sometimes they keep courts closed in Mongolia. You cannot go public. They decide, and then they just read the decisions afterwards.
Well, I'm not quite familiar with that here, but all courts in the United States are open to the public, unless there's a national security concern. Now, can you imagine if there is a very sensitive national security matter? Matters in that case might be sealed.
Who makes a decision on that, whether it is national security?
Well, first of all, the request is made by the parties. Keep in mind, every case that comes to the court is really not a public case. It's a case that two people or two entities, a business, they have a dispute. And if the government is involved in it, and typically they are with a national security case, then those like the National Security Agency or the Department of Justice will make a petition to the court or ask the court by motion, will you declare this matter to be a national security matter? And then the court may hold a hearing. And at the hearing, all the parties are present and make a determination as to whether a showing has been made that that is a matter of national security concern, and it would not be in the best interest of the United States for this to be disclosed.
Okay, my final question on that court hearings, all these texts are available too for public.
All the tapes?
Yeah, text, the wordings.
Absolutely. Not only the opinions, but all of the briefs and all of the documents, the thousands and thousands of documents that go to the court, you can read those too before the court makes the decisions.
So when this digital system now happening, this digitalization happening, is it, say, because it's, say, 5-day speech of many people, and the machine is making into text, right, nowadays?
What do you mean in terms of actually transcribing?
Yes.
They are real-time transcribers in the court systems now, but for the most part, what I see, you still need a live person to make sure it is accurate, and they are certified people. When you are taking actual transcription of testimony there, those certified reporters, some use real-time reporting, but that is only so good. If you've done real-time translation of speeches or language, certified. There are going to be some mistakes there. So you have to have
certified by whom?
The court reporters.
Okay.
Yeah.
So there is a particular system which is certifying the reporters.
Right. But get this, not just the court reporters. It's provided to both of the parties first, to all those in it, and then they get to read it. If they think something is wrong with it, they fix it. So it's not just the court reporter certified and that's the end of it.
Then how you find that, say, 15 years ago, a certain crime happened and there was a trial, court, everything. Mm-hmm. And so now I can go back and to search on where? On Google, or the court system has on?
Well, there's research reporting systems in the United States, typically the court uses, and it's official reports that come out of the court. They actually publish the opinion. They're published in some of the major companies, Westlaw and LexisNexis. Lawyers know this. It's pretty much in the old days, you had to research these cases, you had to use something called Shepard's, and it was a manual process. You would have to go and try to find it. Now, you're correct. You can go online to one of these legal research services, and individual lawyers pay for them and firms pay for them, and they allow you to go in not only to pull the case, they provide interesting topical indexing of them so that you can easily find them and search them, and you can quickly search for terms. The world is totally different when it comes to electronic introduction in the court system now. It has done something you've just asked about, and that is the media presence. How much media presence you think there was in the court system 50 years ago when you go in and you had just your equipment in your hand, your tape recorder and that sort of stuff, yes. And then you were trying to report. Now it's real time. You don't even have to go to the court. You can sit here, listen to the whole argument. You can read all the briefs here, and every bit of the information is in front of you. Yep. It's amazing, isn't it? It's amazing,
yeah. That's what is probably what makes Mongolia learning faster. Yes. Those experiments you have learned, you have did for the last 200 years.
You're starting at a level far beyond 200 years ago, which I just think is just amazing where you're going with it.
My very final, more personal question is: yes. I mean, how do you keep you in such a great form yourself, physical form? Sport, or what do you do?
Well, since I have been here, I've been fortunate to be over at one of the hotels, and they have a nice workout facility over there. I've been the older you get, you become more conscious about those things, that you need to watch out for exercise. And so I typically do that on a daily basis, watch my diet here. The biggest challenge, of course, as I indicated to you earlier, has been, adjusting to the air here. Anyone, as it would be if you went to the United States, you may have a time to adjust. But beyond that, it's just been I've been able to keep in shape and work out pretty well.
Best. Thank you so much.
Thank you. It's been a pleasure. Been a pleasure.
За хүн түзэгчтэй өнөөдөр манай дефактоны түүхийн зочноор Монголд шүүгчдийн холбооны урилгаар ирсэн Америк нэгдсэн улсын шүүгч энэ даван заалдах шүүхийн хүн юм байна. Жэймс Wynn оролцлоо. Баярлалаа.